This morning's docket is full, but each name tells its own story. Marcus Jackson, Antonio Boswell, David Knight. Different cases, same courtroom. What we're watching isn't just routine procedure. It's the system deciding who walks free and who waits. Stay tuned, because one ruling here could shift everything that follows.
What are we doing? Your Honor, there's going to be a waiver. As soon as Mr. Jackson signs the form, I'll give it to the court officer.
You're waiving your right to have a preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on the single count. Mr. Goss.
Your Honor, we acknowledge receipt of a copy of the information. My client waives its further reading, stands mute, asking the not guilty plea be entered.
Defendant every way form of reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
November 19th at 1:30 with Judge Collins.
November 19th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you.
Thank you. Court does call the case People versus Antonio Boswell.
And good morning, Your Honor. For the record, Terry Johnson, P70773, on behalf of Mr. Antonio Boswell, who was present and stands to my right.
Sir, can you state your name?
Antonio Boswell.
Thank you.
I'll put my-
Oh, want to approach? Or-
We can. Your Honor, may we approach?
He looks shady. Yeah, I know. All right. Yeah.
It's
so-
I'm a Spartan. He doesn't,
What?
I know I'm in enemy territory. I'm a Spartan. So, you gotta.
You just don't know how bad the territory is. Just because I'm not a Wolverine.
Oh, I know.
Yeah, you should.
I know.
Okay. This may take a while because I'm Spartan, so he has to talk. We have to talk slow. Come on. All right, record should reflect we've had a bench conference in this case. It's been a request for an adjournment.
You might notice how quickly these early hearings move. When a preliminary examination is waived, it means the defense agrees there's enough evidence to proceed. No witness testimony yet, just paperwork and trust. It's a strategic move. But would you skip a chance to test the evidence early, or play it safe and move forward?
Good morning, I'm Rob Jacob on behalf of Mr. Knight.
Your name, sir?
Good morning, Your Honor. David Knight.
Judge, in this matter, we'd like to set an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or,
I can set it the 18th. I can set it the 25th.
I know, but I can't be here on the 17th. I'll have somebody cover for me. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address bond when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge.
Judge Moore.
I don't think so.
Judge Washington.
That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that my client is self-employed. He's a contractor. He unloads semis. He promises to prepare for all future court hearings. He would ask that if the court does release him, if it has to be, he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. And he's posted bond on his other matter. So he's asking if the court would allow a PR bond in this matter.
Here's where things get tense. A defense attorney asks for bond reduction, claiming his client isn't a flight risk, but the prosecution fires back with assault details that change everything. The judge listens, weighs the risk, and denies it flat. This moment reminds us. In court, timing and trust can mean freedom, or another night in custody.
And was trying to prevent the victim from leaving the room with her child or their child. I would object to any reduction bond this time.
Was he on bond at the time of?
No,
Other matters
he had
at the time of
posted
this?
bond. I believe he had posted bond, right?
Yes, sir.
Well, right, but
I'm sorry,
but
yes.
he's on, he had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating. But yes.
Understood, but he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case, People versus Thomas Gay.
Good morning, Your Honor. Christina Saxon for Thomas Gay, who's on my right. Mr. Gay, please state your name for the court.
Thomas Gay.
Requesting an adjournment.
Yes, Your Honor. I understand that there's a possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
Good morning, Your Honor.
Morning.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Alicia Allen.
Your Honor, we're asking that this matter be set for an exam. All discovery is complete to my knowledge.
And would the people have their witnesses available the 18th?
We can track my data.
Preliminary examination in person will be set for November 18th, 2025. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, denied the request for her to be released to treatment.
Alicia Allen's case hits different. Addiction, danger on the highway, a child in the car, and now a plea for treatment. The defense wants compassion, the prosecution fears risk. The judge hesitates, but keeps her in custody. This is where law meets empathy, and where every decision has real-world consequences. What would you decide?
And this is going to be like third offense with a child as well in the vehicle. So I'm very concerned about her getting out at all this time.
And has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that she'd need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly if there were treatment available, I'm not going to have a problem. I mean, I have some issues. It's more the manner in which, I don't have a problem with the treatment. I have a problem with the manner in which she's released, making sure that we have enough safeguards and controls regarding her release.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look at it.
Will do. Thank you.
All right. Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Atkins. Or Larry. It's Larry. That's right. It's Larry. It's Larry that people messed up. I'm looking at it, I said, I know it's supposed to be. Man, I'm sorry. Go ahead.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins. Yes, I know. Okay.
Your Honor, we did finalize a mitigation report that's been provided to the people. They just need an opportunity to review that. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 a.m. That is a Tuesday.
Tuesday.
Bond will continue. Thank you.
Yeah. Okay.
Court does call the case People versus Robert Burnett. Three cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert Burnett.
And Your Honor, we were here before and we have identified that two of these cases are duplicates, so it's going to be newly filed. I'll have the case number for you here in just a moment. I apologize for the delay. But other than that, I think we are really looking at an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment on one of the cases, 25F55793. We are still looking for media on that case.
On 5793.
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have two case numbers because I'm not sure which one is going to be dismissed.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's
Yeah.
correct, Your Honor. And if I may address bond,
Hang on one moment. Let me make sure my paperwork is right.
Robert Barnett steps up, seeking redemption after addiction and bench warrants. His lawyer argues for treatment, not punishment. The judge listens but recalls old failures, then denies bond again. It's justice wrestling with mercy, a tug of war as old as the courtroom itself. Viewers, what matters more here? Public safety or a second chance?
Yes, all set. Is it gonna really matter?
Ultimately, I think it's going to be the. Oh my gosh, hold on. I think it ended up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
But I believe that one, it will be on the paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
no, Your Honor.
Right, so
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 2020th.
Thank you, Your Honor.
And then as to bond.
Yes, Your Honor, I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
And I do think he was in bench warrant status at the time of the 2025 case.
Yes, he
That
was.
was my objection at the last 5 years.
And that is my same objection. And he was in bench warrant status for a period in time. So I'm gonna, again, deny the request for a bond modification in this matter. Bond will continue. Thank you.
Will Your Honor consider release to treatment?
Pardon?
Will Your Honor consider release to treatment?
Certainly, I typically don't have an objection to somebody being
Thank you.
released to treatment. So the only thing that you have to make sure, I would like a tether on that upon his release because of his failure to appear. And also that if he fails to complete the treatment, that he's returned immediately to the jail.
Absolutely.
All right,
Thank you, Your Honor.
Thank you.
thank you. Court calls case People versus Emily Bates.
And Thornton Water, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Kilma Dadish on behalf of Ms. Bates, who is on Zoom. Ms. Bates, can you unmute and state your name for the record?
Good morning, Your Honor. My name is Emily Bates.
Good morning.
Your Honor, we are asking for, I know I said one last adjournment last time.
You did.
We are
Wrote
incredibly.
it down.
Yes,
And I knew you were not truthful.
but the prosecution have offered something even better. So we're just hoping to adjourn a
So
month.
you're blaming it on
No,
that?
I'm blaming myself completely.
It is my fault.
Always my fault.
Oh,
I'll take it.
taking the hit for you.
You get to choose.
How much more time did you need? To
4 weeks would be great, Your Honor.
4 weeks?
Yes, or 3 weeks. 4.
Emily Bates tries humor to soften the moment, admitting fault and asking for one more delay. The judge's patience is tested, yet she grants it. It's a glimpse of humanity amid formality, mistakes, laughter, second chances. Even in a room built on order, emotion slips through. Sometimes the law listens, sometimes it feels.
On behalf of Mr. Benavides. Mr. Benavides, state your name for the record.
Thank you. Really? I can really?
Your Honor.
What?
We
No,
are.
it's okay. Sometimes there are
You know
just
what it
days
is?
that way.
I have this privacy screen on my computer. It's hard to see. I got to tilt it the right way. We're asking for an adjournment, Your Honor. We do not have a resolution yet for Mr. Benavides, but we're hopeful that we could get one. He does want us to address bond judge.
November 20th, 2025, 9 a.m. Without objection. Yes, that's the bond.
And Your Honor, we're asking that Mr. Benavides be given the opportunity to have a PR bond. I do know that there was an issue. He did miss his court dates. The court was, yep, the court was kind enough to recall the bench warrant, but there was a bond issue relating to testing. I believe there were missed tests. There were 2 missed tests, and then obviously coupled.
That was after I had canceled his warrant. He then didn't test. Right?
I think that is right, Your Honor. I think I might have.
No, yeah, you had it right. I just want to make it very clear for the record.
Yeah, got it. So, Judge, Mr. Benavides reports that he is currently employed. He had been working for the past 90 days before he lost his bond and was subsequently arrested. He reports that he has stable housing. He has family whom he lives with. He does now understand, Judge, the importance of not only coming to court. He has been very active with us in regards to his court dates. He lives in Clinton, Michigan, so he's not very, very local. So it is a bit of a distance. And I can't say that testing was not being done because he could not make it to community corrections, but I know he was having vehicle issues, which is what made him miss court. He knows now, Your Honor, that it's extremely important that he tests as directed by the court, as well as make sure that he communicates with us with any delays in regard to his upcoming hearing.
I don't need a response. Motion for bond reductions tonight. Under the circumstances, bond will continue.
Okay.
Thank you.
Thank you.
Court does call the case. People versus Winona Harvey.
Water Assistant Prosecuting Attorney to the People.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey.
Harvey, can somebody unmute? Can you state your name for me?
Winona Harvey.
Thank you.
Yeah.
All right, what are we doing?
Your Honor, this is an adjourned competency hearing. I have had a chance to review the competency report. My office has gone over the report with Ms. Harvey. We do not object to the report.
She is still incompetent, is that correct? But likely to obtain if she's provided treatment.
That is
she currently in her course of treatment regarding that? Or?
That I don't know, Your Honor. The report was not clear that I saw.
My impression, Your Honor, was that she's not. She's still
active.
Oh, she is still here. Yes.
She has not been. I think she's been found incompetent yet. I think that's what we need to do.
Yes, that's.
I thought this was a review. Hold on a second. I got the wrong one. Okay. All right. Any other additional information?
None, Your Honor. Your Honor, the people are in receipt of the report as well and have reviewed it. We have no objection to the court relying on competency.
This time, the court would find that the defendant is at this current time incompetent to stand trial, but likely to obtain competence within the statutory period. And so when presented with the order, I will sign that, Mr. Gaddy. I will set a review competency hearing for, she's not out of there yet, so give me 90. We'll move it up if necessary.
Judge.
Set a review competency date for February 5th, 2026, 9 a.m. Yes, ma'am.
May I know today's day?
I'm sorry.
May I know what month this is? May I know what's going on? Can I know what's going on? May I know what's going on? Can I know what's going on?
All right, you come back to see me in February.
What month is this?
November.
Can I say, okay, all right.
That's what I'm gonna order. And your
Can I get
bond
some
will
paper?
continue.
Can I get a
We'll
paper?
see you.
Can I get a paper
Pardon?
from the front desk saying when I go to court?
Yeah, your attorney will give you one.
I'll send you a
Where's
notice, Miss Harvey.
No, I don't want to notice.
Okay, you won't miss it. Trust me. All right, thank you.
And that's where today's courtroom journey ends. After hours of rulings, delays, and difficult truths, one thing is clear: justice is never simple. Every face here carries a story, every ruling a ripple. What would you have done differently? If this glimpse into real courtroom life made you think, hit like, drop a comment, and subscribe for more.